Okay, so thank you, Malathi, for your kind introduction, and I'll just echo the comments of the other speakers for thanking the organisers for inviting us to speak. I'm going to chat, so the title of my talk is Pre-Litigation Strategies at the EPO. This sounds really echoey. So I'm going to talk about a couple of strategies that you might use if you are a company that is making a product or planning to make a product, and you're aware of some patent rights that someone else has that you're concerned about. In that case, really what we're looking at is probably not pre-litigation strategies, but avoiding litigation strategies. So some things you can do to try and get rid of those patent rights before you even have to think about litigating them. And then on the other side, I'm just going to have a quick look at a procedure that might be useful if you are a patentee in Europe and you're planning to enforce that, and how you can use a procedure that the EPO makes available to perhaps strengthen your patent, get it into shape before you try and enforce it. So the procedures I'm going to look at briefly are the opposition procedures at the EPO, the procedure for filing third-party observations in relation to an application at the EPO, and also the central limitation procedure that the EPO provides. Okay. So just at the outset, this is just a little timeline of the application procedure at the EPO there. So we'll all know the filing, search, publication, exam, and hopefully grant from the perspective of the patentee. Perhaps hopefully not grant if you're one of those companies that's trying to get rid of someone else's rights. So on that timeline, I've just indicated where the three procedures I mentioned apply. So we've got third-party observations, which is primarily something that we talk about before a patent grants. It does still apply post-grant, but I've put it there in brackets because it's not really something that is used much after grant or particularly useful after grant, but it does apply when there are any proceedings still ongoing at the EPO. Opposition, as I'm sure you know, is something that applies for a limited window after grant, a 9-month window after grant of your European patent. And central limitation is something that applies any time after grant of your European patent. And then national litigation is there as well, because, as you all know, currently, until the unitary patent comes into force, the European patent as a single entity doesn't exist. You get it granted, then you validate it in 1, 2, 3, as many European states as you want. After that, it's a completely independent national right, and if you want to challenge it, it has to be done in national forums. So just a really quick overview of the opposition procedure, because I'm sure a lot of you are fully aware of this, so I'll run through it quickly. So it's a central attack on a European patent. With that central attack at the EPO, you can knock the patent out in all of the states that have been validated. So one attack can knock it out in 10, 15, 20 countries, which, if you're someone who's worried about potentially infringing a patent, is a really good thing. Not such a good thing if you are the patent owner, but it must be filed within 9 months from grant of the European patent. And it's important to note that this is just a consideration of validity of the patent. This is not a forum where infringement is in any way discussed. As far as the EPO is concerned, infringement doesn't exist, which sometimes leads to problems when you're trying to talk to European examiners, but that's the way it works. So the proceedings for an opposition, they're inter partes proceedings. Both the patentee and the opponent or multiple opponents remain party to the proceedings throughout. It's quite possible to have more than one opposition filed against a single patent. In some particularly active industries, it's not uncommon to see 6, 7, 8, 9 even different opponents against a single patent. But the proceedings remain as one single proceedings. There aren't separate hearings for each opponent. Just a second note there. So there is this 9-month window for filing an opposition. It's not extendable. If you miss that window, that's it. You don't have the chance to be an opponent. But there is one sort of very narrow caveat to that allows an assumed infringer to intervene in opposition proceedings. It's very limited circumstances, but if you can prove that infringement proceedings are pending against you in relation to the patent that is being opposed, or that you have received a request to cease infringement of that patent and have instigated proceedings for a non-infringement ruling, then the EPO will allow you to enter those opposition proceedings and become a party. That's something, it's really rare, but it's there. There are three possible outcomes to opposition proceedings. The patent may go through the proceedings and come out completely unscathed, upheld exactly as it was granted, great for the patentee. It may be maintained but have to be amended. So perhaps claim 1 was a bit much, but by the time you got down to claim 4, no prior art issues. After opposition, claim 4 is now claim 1. Or the patent may be revoked completely as if it never existed. The EPO does publish statistics on this. I don't have the exact statistics, but it's roughly a three-way split between those three outcomes. The first instance decision is before the opposition division at the EPO. It's an appealable decision, so that goes up to the Boards of Appeal at the EPO. Very similar forum, so you get 2 bites to deal, to either defend or to attack in opposition proceedings. It's not the quickest procedure out there. If you're doing first instance opposition followed by appeal, you can expect these proceedings to be hanging around for 4 years plus, which is often seen as a drawback to EPO opposition proceedings, but that's where we are in terms of timelines at the moment. I won't talk about this in detail, but just a really brief run through of the procedure for oppositions. It's primarily a written procedure at the outset, a couple of rounds of submissions going backwards and forwards, but there will almost always be an oral hearing at the end of the procedure where all parties get their chance to stand up and address the opposition division. A decision is taken on the day of the hearing, so it's not a situation where everyone argues, you go away, the EPO takes time to think about it and then pronounces. On the day, you will know what the decision is. You don't necessarily know why the decision was made on the day. I think sometimes the opposition division isn't quite sure why the decision was made on the day. They take a couple of months to think about it, and then you'll get the reasons in writing. Okay, really quickly through the grounds of opposition. So there are a defined list of things you can use to attack a patent in an opposition. So the standard patentability requirements, novelty, inventive step, exclusions from patentability, which have been talked about a lot during the course of this conference. Insufficient disclosure, so you can attack a patent if you think it lacks enablement. One note there is that you cannot attack a patent in opposition proceedings for lacking clarity. In theory, the EPO is supposed to be infallible and not allow unclear patents through to grant. That's not necessarily the case, but you cannot use clarity as a ground for opposition. In reality, if there's a clarity issue, it will be attacked. We'll just say we're attacking it for sufficiency. And then added subject matter, which is a really powerful attack in opposition proceedings. I think the EPO loves the added matter provisions, as you all know, and I think they can be quite favourable to resolving a case on added matter because it means they don't have to think about the slightly more tricky issues. So if from an opponent's perspective, you really want to be trying to find an added matter attack, From a patentee perspective, you want to be putting your patent in the best possible shape in terms of the amendments you've made to try and prevent any opponents being able to attack you on added matter. Listed a couple of examples there of the type of amendment that as a prosecutor you want to be avoiding if at all possible. There is a subsection to the added matter provision that means you cannot make amendments during the opposition proceedings that broaden the scope of your claims. One thing that you hear talked about a lot in opposition proceedings is this inescapable trap. So you introduced a limiting restriction into your claims during prosecution, it gets attacked as contravening the added matter provisions during the course of opposition proceedings. The EPO agrees you add matter, so you need to try and resolve that. But because the amendment you're trying to resolve was a limiting amendment, you can't resolve it by taking that amendment away, because that would broaden the scope of the claims. So something you see in opposition proceedings, something to be very aware of when you're talking about the type of amendment you want to make in Europe to avoid putting yourself into the kind of position where you might fall foul of that trap. Just a few considerations if you are a potential opponent. These are really primarily considerations for your attorney, but making sure as many grounds as possible are raised, making sure as many claims as possible are attacked. From a more strategic point of view, thinking about whether you want to file your opposition early in the 9-month period, whether you want to wait till the very last day of the 9-month period. Why might that be important? Well, waiting late, you want to give perhaps the patentee the least possible time to respond to your opposition. Why file on the first day? He's got 9 months extra to think about how he's going to respond to your opposition then. Equally, if you are in one of these contentious areas of technology where you think that it's likely that there might be other people opposing this case as well as you might want to file a little bit before the end of the 9 months. Because if there are multiple opponents, during any proceedings, the various opponents are ordered. And they're ordered in terms of when the first opposition was filed. So if you file the opposition first, that means when it comes to the oral hearing, you're going to be the first person that's allowed to speak, rather than the 5th or 6th person that's allowed to speak. So sometimes you might see people filing just a little bit before that 9-month deadline to try and be opponent number one. Final point there talks about thinking about whether you want to be opposing in your own name or whether you want to oppose anonymously. So it's entirely allowable in Europe to file an opposition through a strawman company. So it may be filed in the name of your European attorneys or a company that has been set up for the purpose of filing oppositions that keep the name of the real opponent hidden. Generally, that's for commercial reasons. You don't want the patentee to know that it's you. But there are a couple of drawbacks of filing anonymously, which you should bear in mind. And it really depends upon what are the substantive issues in your case. If you're filing a case where the issues are quite evidential, you're going to want to be submitting experimental data, you might want to have an expert there helping you. That can be really difficult if you're anonymous, because how do you submit that data? How do you convince the EPO that these are proper experiments? Who are these experiments carried out by? Why should the EPO believe these experiments? So anonymous oppositions can be great, but you need to make sure that your case is a case that is suitable for keeping yourself anonymous. Okay, moving on from opposition to third-party observation.